I believe Guns and Gadgets and a few others have been like, there's one hope that we have that we can file a lawsuit here that goes here that basically nullifies the entire thing. If we're not paying taxes on it, why do we even do it? I'm just like, is that a thing?
I always tell people the easiest way to either get a tangible benefit or stop something bad is to do it in the legislature. Now, whether or not you can actually do that is a different story, but the litigation side of things is expensive, takes a lot of time, and there's no guaranteed result.
Welcome to Gun Club Radio. My name is Aaron, and I'm especially excited to have the conversation today because if you've been paying attention to the news, and this is one of those episodes that's a little bit more timely, check the dates to kind of see what, who, what, where, when, and why we're talking about this particular issue. But if you've been watching the news kind of more recently, there was something called the Big Beautiful Bill. Depending on where you kind of land in the political aisle, that bill was either more or less beautiful. And depending on where you are in the Second Amendment conversation, the bill was more or less kind of tumultuous because there was what was considered a once in a lifetime chance, something that guys who have been around much longer than myself with much more wisdom and experience, when they saw what was on the table, they said, this hasn't been around since, pretty much ever. In the history of gun rights being taken away, we've never had an opportunity like this to have them return to the people. It's one of those things where I guess his rights are, once they're gone, it seems. And I think that that trend is kind of continuing, but maybe there's hope. And I'll give you guys a brief synopsis. There was an opportunity for what was called the Hearing Protection Act to go through, which would more or less remove suppressors, the muzzle device that goes on the end of pretty much any firearm, that would lessen the dBs, the overall loudness of the firearm, and make it more tame, less obnoxious, and more suitable to humans, as in less dangerous for your overall hearing. I even have a little bit of hearing issues because I've been shooting firearms, and sometimes you get exposed to, rifles that are way louder than your little earplugs can handle. And so that bill was going to be big in returning the right of civilians and, just regular people to be able to go out and buy suppressors without having to file additional paperwork with the federal government, in addition to paying a $200 tax to the government, and then waiting for however long they decide, and maybe they'll kick it back because you wrote the wrong thing on a piece of paper, and it's just kind of a mess. Those people like myself said that, that's cool, but like whatever happened to short barrel rifles? We're not talking like something crazy and weird. We're talking, hey, the gun is less than 26 inches overall, or has, say, a 14-inch barrel versus a 16-inch barrel. Makes it so much more dangerous, right? No, it doesn't. It just makes it shorter. And in fact, somebody might say less dangerous if you know about like velocity. Fast forward to when the bill passed the House, we were all excited. Oh my gosh, what? And it went to the Senate. There was an individual there. Was it the Senate parliamentarian? I'll have our guest kind of explain maybe just a little bit about that process. But they more or less kicked it back and said, like, yeah, you guys can't do this because of this and this because of that. Some things that are considered kind of arbitrary, and there are ways around that ruling. Those things were not done, and now we have like half of what we asked for. That half being now, presumably, there's no $200 tax stamp, but you still have to file. And presumably, they can still deny you if they don't like something on your paperwork. And they can still, of course, track you and have rights to come inspect your firearms that are on this national list that they have. So fast forward to GunCon. Big shout out to John Patton, the creator of GunCon, and of course the host, and the Gun Collective. If you ever heard of him, he does a great job of recapping the news. We went out to his event, and I had a chance to talk to one of his good friends and co-host of his show, who does the Second Amendment news portion. And I talked to Adam. We had some good words, and one of the things I really wanted to bring him on to discuss was this issue. Like, what the heck happened? Is there anything we can do because I'm hearing there's, well, we can still do this, or we can file this lawsuit. And I'm just like, don't give me hope. Let's go ahead and talk to Adam. I think he might have something good to say. Adam, welcome to the show.
Hey, thanks for having me.
Yeah. So, I mean, that intro, I'm sure, went on forever, but
real somber.
it was a little drab, little dreary.
Whose funeral are we at?
The one of the our gun rights. It feels like. I mean, I know we're still fighting. Second Amendment Foundation. That's your thing that you're working on. What's your position with the organization?
So I'm the executive director.
The executive director.
Yep.
And so your hands are in the pot.
You could say that, yeah. I started at SAF in November of 2022, so I've been here just shy of 3 years now.
Okay, so 3 years strong. You've seen some good stuff. You've seen some awkward stuff.
It's I mean, I started my time in this whole space. I started managing a gun shop when I was still in law school, but my entire legal practice revolved around firearms and firearms rights, and that started in 2014 for 5 years before I went to a different nonprofit. So I've been doing this for about a decade at the national level for like the last 6 years, and certainly over that time seen some things that have been quite interesting and very disappointing at times.
Yeah, and I don't want to make it seem like 2A organizations haven't done, a bang up job with certain battles. And we have the Bruin decision, we have all that, and things that get pushed to the Supreme Court. And of course, there was the bump stock deal, getting that finally reversed. That's major. But before we kind of dive into the list of things that Second Amendment Foundation has done and done well, and some of the battles that you guys are still kind of working on, can we talk about what went wrong? Because this is not your guys' fault. Like, what went wrong with the Senate and getting this bill passed? Because it was bunched in there with a bunch of other stuff. Some stuff I don't agree with, but hey, we were going to finally get something, right?
Sure. Yeah, so I mean, I think that there's a number of things. I think the easiest place to start is kind of how it was all teed up. And I think once it became a reality that reconciliation was a viable means to push the HPA, there was some other language that other groups started to push, including the stuff that you would have found in what was the Short Act. And when we look at those bills, had they gone through the traditional process, there's no way they would have come out of the Senate at all. And the reason for that is because the filibuster is still intact, and the filibuster means that you need 60 votes to invoke cloture to end the debate and bring a bill to a vote. And you just wouldn't have 60 votes with the way the Senate is comprised. There's not enough Republicans and independents to get to 60 without some Democrats crossing over. And for the Democrats, that would just be a political grenade to sit on. So they weren't going to do that. So reconciliation became the manner in which these had any viable pathway to potentially becoming reality. So the House, passed its language, which included the HPA and ultimately the Short Act, and it went on over to portions of those anyway, and it went on over to the Senate. The Senate parliamentarian, the individual over there, she's been serving in that role since 2012. So she survived both Republican and Democrat controlled Senates. And the role of the parliamentarian is advisory. It's to advise the presiding officer as to the rules and procedures of the Senate. You can find parliamentarians in other things as well, like organizations that run meetings using Robert's rules, things like that, where there's somebody just kind of advising as to, hey, this is in compliance with the rules or not. And so the position, ultimately, you don't have to follow what the parliamentarian says. But typically you have the parliamentarian there to advise you as to, yes, this is in fact correct or not. And there have been instances in the past where the parliamentarian has been overruled. So taking all that into account, you get the language coming over to the Senate. the bird rule, and I think this is where groups that were very vocal about this, particularly as steam picked up in the House, I don't think they did a good job of kind of managing expectations of people who were consuming the information as far as, hey, it may come out of the House, but there is this rule in the Senate that potentially could be a problem. And ultimately it became a problem. Now, whether or not it could have survived the bird rule or not, I'm not going to pontificate on that. But the bird rule essentially is reconciliation deals with budgetary issues. And if the measure is policy based, the Byrd rule says it goes. And this is adopted after Senator Byrd, and this has been around for quite a while now. However, if you do have a budgetary related matter, like let's say lowering a tax or eliminating a tax, and you make some conforming amendments to other areas of the law that are because of that budgetary thing, that would pass the Byrd rule. And so that was the argument with this essentially, was that, well, the way the NFA is structured, you have a $200 tax on the making, manufacturing, and transfer of these items. And if we eliminate that, then the registration requirements and, essentially being in the NFA at all, we could amend that area of the law and still comply with the Byrd rule. And so ultimately what happened was the Senate parliamentarian threw that language out. And the best that the Senate was apparently willing to do was lower the tax on the registration, on the manufacturing and transfer of silencers, short barrel rifles, short barrel shotguns, and any other weapons from $200 to $0, and $5 to 0 for the AOW on the transfer. So that's where it sits today. And while it's certainly not best case scenario, and I'm not gonna say that it is. It is. While a lot of people, I think, are very vocal about being upset that the gun owning community somehow got screwed, you also, in a lot of ways, have a fairly significant step in reversing a law that's been around since 1934. Now, I say that, and I will also readily admit that, the tax, the $200 or the $5 for an AOW, really not the thing that upsets most people. $200 is $200, and for some people buying the stuff that might be a big deal. But I think most people, it was the registration and the entire NFA process that was the sticking point in what they were upset about. And I get it. Yeah. I own a number of NFA things, and it is a pain for sure.
Yeah, that for me and many other people. And some people have avoided going into any sort of NFA item, not because they don't absolutely want one, but because they can't quite get behind the idea of voluntarily putting themselves on a government list.
You're already on a
people
list.
People say, well, if you're not on a list,
you're already on a list. You own a car, you're on a list. I mean, that's the reality of it. Now, I get that. For me, that was just something that, like, I want the thing. I don't really care. And at this point in my life, I'm all over the internet holding guns and other things. So the government knows I have guns. It's not a secret. Hell, I'm doing your show.
But I guess the real argument is like, okay, so they have the secret database of gun owners based on the the transfer forms. Whenever you go into a gun store or FFL, they got to do their transfer, and they have your information. They really do. And in fact, if you buy more than, what is it, like 2 handguns? If you buy more than 2, you're on another list.
Multi-sale form, and then if you're on a border state, it includes long guns too.
Mm-hmm. And so it's like, okay, so there's already all this infringement. If you talk to any 2A absolutists, they're going to call it that all day. Any gun law is infringement. And I think there are people who maybe they're okay with some, but ultimately the concept of, like, we had all this like pie in the sky hope, and it felt like, were we sold a bill of goods, or did somebody like betray us? That's kind of, I guess that's my question to you, Adam. Like, you kind of mentioned it earlier. You're like, hey, we should have managed expectations better. You say we. the people sharing the information.
People sharing information, yeah, and particularly the groups that were on Capitol Hill lobbying that may have made it seem that it was, you know, a done deal. You saw that previously with the HPA the first time it was introduced back in 2016, where the way it was presented and marketed, it kind of made everybody believe that it was, you know, in the bag. And I can tell you, like, from at that time, I was still working at a gun shop part time, and I can't tell you how many people came in and said, "Well, I'm waiting for the HPA to pass before I buy one of these things." Well, you're going to be waiting a while. Um, I think ultimately, at the end of the day, I think the information provided to people and somewhat of a lack of clarity in how the actual procedural process works in these things, you know, complicates it and creates sometimes an illusion that things are certainly a, you know, done deal, if you will.
Yeah.
Um, you know, whether somebody betrayed us or not, I don't know. I wasn't there. You could say that, sure, but I don't know if you could have find any definitive proof of that.
Mm-hmm.
No, I think unfortunately at the end of the day, it's politics, and
Yeah.
you know, that's just what it is. And then on top of that, I think, you know, from a standpoint of just priorities of the Senate and the government, gun stuff was not a big priority in the grand scheme of things. You know,
Yeah.
you have
Not
issues
at
like
all.
immigration,
And
the economy, you know, etc.
I mean, honestly, like if you really think about it, in my opinion, it was only going to sneak through because it was packaged with everything else. Because it seems as if, you know, like we've had the pro gun party, quote unquote, running things for a little bit now. It's been a few months, and only now are we getting something substantial. But like you said, the filibuster, 60 votes, all that. Um, how much do gun owners really have when it comes to their hopes and dreams of getting stuff really pushed forward and pushed through?
Yeah, I mean, so keep in mind, as you know, you're aware, and anybody who paid attention in high school civics, there's three branches of government, right? Like
Mm-hmm.
Congress makes laws, and right now the Republicans have a majority in the House, but the filibuster presents a problem in the Senate, and half the time they can't agree what color the sky is. So,
Yeah.
good luck getting something controversial through, let alone, you know,
Right.
something that maybe is less controversial. But I think, you know, you look at Trump's second administration versus his first, and I think he has done some pretty significant things for gun owners. Now, is it going to be what everybody wants or what some of your listeners want as far as it applies to them? No, probably not. But you look at, you know, the Harmeet Dillon in the Civil Rights Division of DOJ, you know, investigating Los Angeles County Sheriff's Department for CCW delays that are taking up to 18 months to process. Like,
See,
that's
that's
something the
actually a big
government's never
one.
done.
Yeah,
Right.
that's
That's
huge.
something the government's never done. You look at Pam Bondi, and I know she's controversial in this area, but
She's
she rescinded it.
taking a few
She,
L's.
yeah, I mean, she rescinded ATF's authority to conduct federal farms relief determinations, and that's a big deal as well. Now, it sounds negative on its face, but since 92, Congress, through the appropriations, has said that ATF cannot use any of the funds appropriated to it to conduct those relief determinations. And on top of that, you as an individual can't self-fund it. So if you're federally prohibited, let's say you were convicted of a non-violent misdemeanor that for whatever reason you can't get expunged or, you know, relief at your state, and it triggers 922 G1, you're just screwed. And so the mechanism that people have tried has been suing in court, saying that, hey, as applied to me, this prohibition is unconstitutional. And I've litigated a number of these cases over the years and been involved with them. And almost always the courts say, yeah, too bad. So there's no way you're forever prohibited from exercising your Second Amendment right for sometimes the stupidest thing that has no element of violence and might have been a bad decision you made when you were younger and you've completely changed as a person. you look at some of the things ATF has done. It rescinded the importation ban on non-lethal training ammo. It's revised its position on importing dual-use barrels. The DOJ filed a couple of amicus briefs, one in our assault weapons ban challenge in Illinois, where it said that these are protected arms, and in fact said silencers are arms under the Second Amendment. You get them filing a amicus brief at the Supreme Court for a case that's seeking to be heard, saying that Hawaii's ban on carry is, infringing the Second Amendment, like things that the federal government has never done before. So again, while it may not be what your listener, when they look at it, go like, well, that doesn't affect me, I don't care, I want the big thing.
Right.
I think relative to his first term, he's certainly delivered a lot more and been more true to his word of supporting gun owners. Not going to claim it's perfect though.
Yeah, I'm wondering if he's finally listened to his son a little bit, because, like, man, like anybody who's seen Eric Trump's kind of thing that he's done recently is he's really into guns, and I'm just like, oh, okay. I think we got a little bit of help, guys.
Yeah,
I think he's part owner of the like a sportsman magazine, pretty much, Gear and Sports and whatnot. So that's helpful.
And then Don Jr. He's on the board of Grab a Gun, which went public today, I think, actually, and he also does Field Ethos magazine. I think he's involved with that as well.
Somehow I confuse the names. Don Jr., not Eric.
Yeah. So, it's like I said, it's not perfect. It's not everything that I would say like, hey, I want, and I think the administration should be doing. But at the same time, the administration's got a billion things on its plate that it's trying to do. And, when it comes to priorities, I can almost guarantee you that guns are not going to be the priority item.
Yeah, it's interesting because there's a lot of us who, and there's a few other things I want to hit on, because, I do want to talk about Second Amendment Foundation and some of the work that you guys have done. And I mean, I guess there's one of my guys in the Discord had a question about some things, and so we can talk a little bit about that. But
sure,
I guess the idea of the single issue voter saying like, dude, I want to vote for the guy who's going to protect the Second Amendment, and then it's like, truthfully, it's not the highest priority, but you did list out a lot of different big wins, because everyone's a big win, big wins that actually put the gun owner, depending on your location and state and different things, at a better advantage when it comes to the legal ramifications of all of this, right? Being able to actually obtain a firearm, because the California is wild, and getting a gun in LA legally is extremely difficult, according to everyone I know who's kind of been through that process. And even look at Maryland, it's so expensive in order to get into firearms, with the classes and the permits and all that. But let's unless you had something specific you wanted to add to that, I do want to talk about Second Amendment Foundation.
No, I mean, I think the only, to put a point on it, I think at the end of the day, you're dealing with politicians. They can say whatever they want on their website, and this isn't specific to the president, but more broadly, any of them. They can say whatever they want, but when it comes time to put their money where their mouth is, that potentially becomes a different story. And also, they're concerned about their constituency. And if you're not part of their constituency, your opinion really doesn't matter, because you're not reelecting them or defeating them necessarily. It's like I said, there's three branches of government that can be a very good thing. And I think, unfortunately, as far as Congress doing something at the federal level, probably unlikely given the makeup of it.
Well, I'm glad you brought that up, because it actually reminds me there is something that guys have been talking about, especially like the YouTube gun news guys, like the Guns and Gadgets of the world, and the Armed Scholars of the world, guys you've met before, and I'm sure to a certain degree, who are like, there's one hope that we have, their whole like 1 to 16 billion videos a day, because those guys have a crazy release schedule. I'm not sure how they do it, but
Yeah.
it's
It's
like,
their job.
it's their whole job. I'm just like, all right, cool. As a guy who has a day job, I'm just like, I don't know how y'all do it, but um, I believe Guns and Gadgets and a few others have been like, there's one hope that we have that we can file a lawsuit here that goes here that basically nullifies the entire thing. If we're not paying taxes on it, why do we even do it? I'm just like, is that a thing? Is that
It
real?
it is, and I mean we can talk about it later. But we along with NRA and the American Suppressor Association and FPC are going to be filing lawsuits challenging that exact thing. So it is. It doesn't mean that that was a let's find a way to make this not be real so we can file a lawsuit. I always tell people the easiest way to either get a tangible benefit or stop something bad is to do it in the legislature. Now, whether or not you can actually do that is a different story, but the litigation side of things is expensive, takes a lot of time, and there's no guaranteed result.
Mm-hmm. And I guess that'll be some of the answers that we receive later when we talk about some of the issues that you guys have run into as Second Amendment Foundation out there doing the work. Although let's kind of recognize what you just said to a foundation isn't just rolling over when it comes to like, okay, guys, you guys got your free tax stamps. Congratulations. We're gonna go work on other things and pretend to kind of be a Second Amendment group. You guys are still pushing forward and spending money and doing the hard work because I'm sure, I mean, you went to law school. Doing all that is not easy. Like I didn't do well in school. I'll just put it that way. So can we let's talk because you talked a little bit about kind of like how you got into Second Amendment Foundation, like just briefly, right? And
Yeah.
did you work with any other organizations? Was it you or was it somebody else?
Yes, I spent 3 years at FPC.
Right. The infamous Twitter account.
The very
Yeah.
one.
Who runs their social media, first of all? Can you say?
Don't know. Not there. So I haven't been there for 3 years, so I have no idea.
Yeah, I guess it's been a while, but I swear their answer to everything is like "f you no," like it's just everything. Like gotta be crazy. Anyways, but let's focus on what you do know about Second Amendment Foundation. You've been doing this thing for 3 years.
Mm-hmm.
What I guess where did the Second Amendment Foundation, where did it come from, and what have you guys been up to recently outside of the stuff we just talked about?
Sure. So the foundation was founded in 1974 by Alan Gottlieb. And the whole idea, and I guess the brief story on Alan was he was involved in a lot of political things when he was in college. He worked for Young Americans for Freedom, the national group. He got tapped to run a state chapter, specifically the one that, or regional chapter, the one that dealt with the right to keep and bear arms. So that brought him up to Bellevue, Washington. And that ultimately became the Citizens Committee for the Right to Keep and Bear Arms, the sister C4, which was founded 3 years prior to SAF. So when SAF was founded, the whole idea behind it was building a foundation to elevate a case to the Supreme Court. And you have to remember at that time, there was still a scholarly debate as to whether the Second Amendment was an individual or collective right. So a lot of the early work of the organization was writing scholarly articles and law review articles and working with scholars and lawyers to get the history and things published to ultimately frame stuff to elevate a case to the Supreme Court. The foundation did do legal work in the early years. Its first lawsuit was actually against then Mayor Dianne Feinstein and her total handgun ban in San Francisco, which we won. And a year later, we filed almost the same exact suit against a town in Connecticut, which we also won. The 80s roll around, you get Gun Rights Policy Conference, which still goes on to this day. This year was the 40th annual one, and it's at the end of September out in Salt Lake City. And that's a meeting of the minds, if you will. So lawyers, scholars, activists, where they get together and talk about the current state of the Second Amendment strategy, share things. So you're really dealing with the people who are kind of involved in the day-to-day aspect of trying to restore and advance Second Amendment rights. The legal program here at SAF, I think, is what we're most well known for. There is an educational component, and that's something we're working to continue to build out this year, with particularly with one of our new hires recently. But the legal program, since our inception, we've been involved in over 260 lawsuits, either where we filed it, where we've funded it, or we filed an amicus brief in someone else's case. As of right now, we have over 55 active lawsuits, and we've had a number of precedent-setting wins across the country, including the Supreme Court, the second major Supreme Court decision on the Second Amendment. If you ignore the Miller decision from the 30s, you get Heller in 2008. McDonald versus City of Chicago was SAF's case, and that's the case that allows all of these groups, including us, to sue the various states and municipalities for Second Amendment violations. So that was a SAF case. And then, of course, we have a number of circuit court wins as well. The Azell series of cases up in Chicago. I mentioned prohibited persons earlier. SAF funded a challenge dealing with an as-applied challenge to two individuals in the Third Circuit, which was precedent setting, where the Third Circuit said, yeah, as applied to you, that law is unconstitutional. And that actually formed the basis for a lot of the work I did in private practice as it related to as applied challenges. Post Katrina, they sued New Orleans over the confiscation and got a consent decree. They had sued, I think it was I'm going to forget which state it was, but over a non-carry thing. There's such a rich history of litigation and a lot of success in it, which is, again, what we're kind of known for. Not to say that we, like everyone else, haven't suffered losses, and it can certainly be very frustrating, particularly when you see how it affects individuals. And when you're doing this, you're not only doing it for the individual in the case. A lot of times, the way I explain it to people is we basically operate as kind of like a public interest law firm. And when I explain how our legal program works to people, I tell them, consider we have three different buckets. We have our strategic litigation, which is we look and see what the state of the Second Amendment case law is today and how we want to shape it for the future and make it better for Second Amendment rights. So we plan cases specifically to advance and restore the Second Amendment. Then I have what we call opportunistic litigation. So somebody sends us an email, calls us and says, hey, I've got this problem. And we look at the problem and we determine that there is a public benefit to bringing a lawsuit on behalf of this individual, because not only can we help them, but the precedent we establish in that case can help many other people as well. So the public interest side of things in part. And then I have what I call kind of responsive litigation. So I'll use Bruin as the example. Supreme Court decides Bruin, affirms that the test in Heller is the test that's supposed to be applied to Second Amendment cases, and also affirms that you do have a right to carry outside of the home. So what happens? Well, New York, New Jersey, Maryland, California, they all passed laws saying, yeah, that's great. You can carry, but you can't carry in these sensitive places. And by the way, we're going to say everything's a sensitive place. So that would be like the responsive litigation where, you get something positive, the states go and pass a new law, and it's okay, well, we can't allow that law to actually continue to be a thing without us challenging it. So that's exactly what we did in that instance.
Yeah. Well, you mentioned a bazillion and six lawsuits. I would have interrupted you, but I can't keep up with your scholarly mind. That said, it sounds like I'm being sarcastic because I have such a flat voice. But the fact that you could rattle off all these different cases as things that have made a real impact and things that SAF or Second Amendment Foundation has been able to be a part of or accomplish directly, I think that speaks to the legacy of the organization overall, and to be like, hey, listen, if you're going to support somebody, support people with, W's under their belt. Like, we got a wall of championship belts in the background.
Mm-hmm.
You gotta hop on and support this thing because this train is going forward. That said, the Rondi Azell case, I found it to be fascinating because we actually had the absolute privilege of having her on the show kind of earlier on in our, I guess, running. And she's a firecracker. And I feel like it's her and only her, maybe like two other people in the entire city could have worked that case with you guys and got that thing accomplished. And I'm just, my only thing that I regret or feel sadly about is that up until the point we had that conversation, no one had taken the opportunity to get that range open within the city limits. That was what her case was about. Is and correct me if I'm maybe mistaken on something. Building a range within the city limits of Chicago.
Yeah, that's what that one was about. The first one. There were two.
I mean, she beat the city twice. That's crazy to me.
Mm-hmm.
How do you even do that? Good team.
Yeah, I mean, the one thing I will say is we have prided ourselves on hiring outside counsel that's extremely competent and making sure that we work with the best lawyers we can and coming up with the best theories, and we don't rush things. If we're going to file it, we want to make sure it's done correctly. You see sometimes groups rushing to file so that they get the PR splash, and then you read the pleadings and it's not all that great, or maybe 3 steps down the line there's stuff that you could have planned for and thought through a little better that wasn't.
It sounds like that's what you guys do. Is, I mean, you say like, hey, we try to like stack the cards and to be able to fall a certain way. Once, if we win this, it will do this and it will trigger that, and these things will come into place, and then we could sue here, and I'm sure we can get 3 groups to come in. It's like, you guys are extremely strategic, which is great because we only have so many dollars to pump into groups. Can we be smart about things? But
sure.
What would you say, or would you say that is the biggest weakness of, I guess, Second Amendment groups that get together and go sue happy and do the thing?
No,
because they're not really thinking ahead, or what was the deal?
I don't want to say that they're not thinking ahead. I think in some instances there are times where somebody rushes to the courthouse, and it doesn't even necessarily have to be a group for that matter. Sometimes you get some individual who gets an idea and they just, I want to go file this lawsuit and challenge the thing, and they haven't, or their lawyer hasn't stopped to consider, okay, well, if I do this without maybe consulting with people who are a little more familiar with it, like what are the ramifications for it? There's been instances where we've taken over cases from either pro se individuals or other lawyers because it could have created bad case law, which ultimately would be very bad for us and the Second Amendment community at large.
Is there an example of that? Because I'm sure there's people who are just like, what the heck are you talking about?
Yeah. So, okay. So pro se would be when somebody represents themselves. So the example I'll give you for this was when I was in between jobs for about 3 months, let's call it.
I know it.
Yeah.
That's gotta suck.
I swore I was never going to practice law again, but here I go. There was a 18-year-old and his buddy who filed a lawsuit in West Virginia, challenging, among other things, like tobacco purchases and stuff, the federal handgun ban. 18 to 20, transfers from FFLs to 18 to 20-year-olds, the ban on that.
Yeah, they're going to tear them apart.
That came to our attention, and I had been talking to Alan about a couple things, and so he asked if I wanted to litigate the case. I said, sure. So I contacted the kid and chatted with him and said, hey, the Second Amendment Foundation is interested in taking on your case. No charge to you. We see a public benefit to doing this. If you're cool with that, we'll do it. But the tobacco stuff's got to go. And yeah, sure. Talked to his buddy. His buddy was on board, and so we took over their pro se challenge, and we won at the district court. Now it went up to the Fourth Circuit. The Fourth Circuit reversed, which was not surprising. We knew that was going to be the case because it's a bad circuit to be in for gun rights. And we're currently working on a cert petition to file with the Supreme Court to take that case. Whether they will or not, we'll find out.
Because they don't take anything, it seems like, when it comes to actual firearms stuff.
Yeah.
Once in a while, and it feels innocuous.
I'll touch on that in 1 second. But the reason this case, I think, and again, I'm not saying that the court's going to take it, but we also had the same exact case that we filed in Louisiana where we lost in the district court. It went up to the Fifth Circuit. The Fifth Circuit reversed, saying the ban was unconstitutional. And the timeline for the government to petition for cert expired like a little over a week or 2 weeks ago now. recently, very recently. So they didn't seek Supreme Court review on that. So it'll be interesting to see what their response is when we file a petition as far as, hey, Supreme Court, we want you to take this, whether this administration is going to say, yeah, we do think there's some problems with this or not, or whether they're going to, defend the law. But it'll be interesting. So the Supreme Court in taking cases. Yeah, the majority of cases that come to the Supreme Court's door, regardless of topic, are never heard. The Supreme Court typically looks for a couple things. One being that there's a circuit split. So the various circuits throughout the country have rendered different decisions, and they want to level the playing field so everybody's on the same page, so you don't have the law being applied one way in this part of the country and a different way in a separate part of the country. If there is a case of particular importance, that's another one, and you could, I guess everybody has a different definition of what is important, but that would be another reason. So when we look at Second Amendment stuff in particular, and again, if we just kind of ignore Miller from the 30s for the purposes of this discussion, you get Heller in 2008. Heller says individual right untethered to militia service. It also talked about, and a right to keep your arms in your home. It also did talk about bear, and I think Heller was pretty clear that you have a right to bear them outside the home as well. But that only applied to the federal government because that was a challenge to the District of Columbia, which is a federal enclave. In 2010, you get McDonald, which, as I mentioned earlier, was the case that allows us to now sue all the various states and municipalities. And what happened was the Supreme Court incorporated the Second Amendment against the states via the Due Process Clause of the 14th Amendment. Some legal jargon for you guys. You get Catano in 2016, which is a per curiam opinion, which means that the court just agreed on it, saying that the stun gun ban in Massachusetts, that stun guns were, they're arms, number one, just because they didn't exist at the time of the founding, and they're protected. And then you get Bruin in 2022, the summer there. And so Bruin reaffirms the test against, that's applied to Second Amendment challenges that was spelled out in Heller, that being the text of the Second Amendment. So is the plain text implicated? And then as informed by our nation's history and tradition. So what that means essentially is that if in our nation's history, and again, there still exists a scholarly debate, although I think the Supreme Court was pretty clear that the time of the founding is the proper time to look, not the time of adoption of the 14th Amendment, that if there is a historical law that is analogous to the current one, it may be constitutional, whatever that restriction is. And if it's not analogous, then it would be unconstitutional. The next decision by the Supreme Court dealing with Second Amendment stuff was Raheem. And Raheem dealt with an individual who was arrested and charged with being a felon in possession. He had some quite the criminal history, and this was not an ideal case for the Supreme Court to take if you're looking for advancing Second Amendment rights. So ultimately what the court concluded was that the prohibition against him was in fact constitutional, and that they used the surety laws and going arms statutes to basically say there's analogous laws to the current prohibition on him. And so the point of recounting all those Supreme Court cases is this. When you look at how the Supreme Court has decided Second Amendment issues, it started with individual rights, right to bear arms in the home, untethered to militia service, expanded that interpretation to it applies against the states as well. It dealt with carry in Bruin, and then after Bruin, you get kind of like the next natural thing, which the reason they took Raheem was because the Fifth Circuit found that prohibition was unconstitutional, and I think the court just figured that couldn't stand. So if you look at what the court really could address next, from a realistic kind of baby steps on the issue in developing Second Amendment jurisprudence, you have things like assault weapons bans, magazine capacity restrictions, age restrictions, and more on the carry issue, like sensitive places where you can and can't carry, and really kind of expounding on that. Now, some of you may say, well, Adam, that's great, but didn't they just reject an assault weapons ban challenge? And the answer is yes, they did reject Snope, which was our assault weapons ban challenge that came out of Maryland. And they also rejected defeated a case that came out of Rhode Island dealing with the magazine issue. Now, that was on a preliminary injunction. We don't really need to discuss that. All you need to know is the Supreme Court doesn't like cases in that procedural posture, and that means that there wasn't a final decision by the lower courts on it. It was very early in that case. So with them rejecting Snope, it wasn't without some comments from the justices. And what you get out of that was, that Thomas, Alito, and Gorsuch would have voted to grant cert. So 3 of the 4 justices you would need to get cert granted are already there. Thomas dissents, saying that we should take this case. We need to decide the issue. And you have Kavanaugh, who says in a statement respecting the denial of cert that he believes that the court should address this issue and will likely do so in the next term or 2. So realistically, we have 7 assault weapons ban challenges pending now. One is in Illinois, which is probably a very good vehicle, trial record behind it. It's currently being argued, briefed in front of the 7th Circuit. So in the next term or 2, we'll have another cert petition before the Supreme Court, and hopefully they'll be willing to finally take one of those cases and put this issue to bed, that these so-called assault weapons are in fact common arms in use for lawful purposes and constitutionally protected. So, long drawn out way of saying that.
No, that's interesting. It had my wheels spinning the entire time. I was like, wait, so you're telling me there had to be a whole court case to decide that the Constitution as it was written isn't really talking about like militia. They're talking about something else, because like Corleone War, you are the militia, but it's like, who's decided that? But it's already been decided.
Well, I mean, the militia is also in statute. There is a statutory provision of who qualifies for the militia. But the militia was basically able-bodied at the time men that were part of it. But really, it wasn't that who's part of the militia as much as that the right to keep and bear arms is untethered to the militia service. So it exists independent of whether or not you're in the militia.
Okay.
And that was a scholarly debate as to whether or not this was a collective right in the sense of, for the common defense versus you as an individual. And that debate was settled with the Heller decision.
Yeah, that's fascinating. And we'll have to geek out about that a little bit more. But you fast forwarded to the cases that you guys couldn't take, and the case that was kind of presented, but in general, it's kind of like knowing that justices in the Supreme Court wouldn't take that because it's like pretty much in the wrong phase of its life as a case. I know you said like procedural something legal jargon.
A preliminary injunction. Yeah.
Preliminary injunction. I make myself sound like a knucklehead, like I didn't go to school.
No. I mean, look, the legal stuff it can be very confusing. Hell, there's times where I'm looking at I got to read this a couple times because I'm not sure what it says. But for your listeners' information, the preliminary injunctions are something that are filed very early on when a case is at the trial court, and basically you're asking the court to enjoin or stop the enforcement of whatever's being challenged. It's in our context anyway. During the pendency of that case. So you're asking them for upfront kind of like, hey, stop the government from enforcing this law while we litigate the issue. And then ultimately you reach a final conclusion. So in this instance, the court denied that request. The plaintiffs in that case, the people who brought it, appealed that decision to the circuit court, the court above, the intermediate appellate court. They also declined to grant that request. And so they went to the Supreme Court asking the Supreme Court to weigh in. And the point of that was really that the Supreme Court doesn't like to address things at that point in time. It really wants the lower courts to kind of sort it all out.
Fascinating. Because I suppose that the problem with the Supreme Court is once they decide something, like that's it. Like it's done.
Well, you would think. You would think. And yes, it's done in the sense of they've decided it, but the lower courts have a very funny way of going, oh, you said this? Like, cool, we're going to do this. And not do the thing the Supreme Court told them to do, which is exactly what we saw from 2010 through Bruin. really, with Second Amendment cases, with the way the lower courts took those cases and then applied a test to them. They kind of created their own test that wasn't what the Supreme Court said the test should be, and that was a very frustrating thing for
Would you be able to
12
kind of
years.
like gloss over that? I don't want to keep you too much longer because I know we've
No,
been talking for a while. But are you able to
sure.
kind of share kind of
Yeah.
like what you meant by that?
Yeah. Yeah, so I mentioned earlier the test that the Supreme Court reaffirmed in Bruin, text of the Second Amendment as informed by the nation's history and tradition. And so in the interim period between really McDonald and Bruin, you get these courts coming up with this two-step test, basically saying, does it implicate the Second Amendment? And I'm like, okay, if it does, then step two. Well, what level of scrutiny do we apply? And there's three main levels of scrutiny. You have strict scrutiny, intermediate scrutiny, and rational basis. And essentially, strict scrutiny is where the government has an extremely high burden to show that there's a compelling government interest and that what they're doing is the least restrictive way to implement the law. Intermediate scrutiny is kind of in the middle where there's more leeway with the government and its restriction. It's not a compelling interest. It's just a important government interest. And then rational basis is just kind of like, well, does it make sense? Is it rational? So that's the lowest tier scrutiny. So all the courts said rational basis out the window. We're not going to apply that. Strict scrutiny is the one that should have been applied because you're dealing with a constitutional right. And almost every court in every instance went, yeah, we're not going to do that. We're going to apply intermediate scrutiny. And when you go to the intermediate scrutiny level, there's enough leeway there where you fine for the government. And that's exactly what happened for 12 years, where a lot of these cases, they would apply intermediate scrutiny. They would interest balance the constitutional right versus the government's interest, and almost always come out on the side of, well, the government has an interest that, makes, based on the tier of scrutiny, that we can uphold this law as constitutional. The other very frustrating thing, if you had mentioned California, I had mentioned California too, for that matter, but California's in the Ninth Circuit Court of Appeals, and in between McDonald and Bruin, they heard 50 Second Amendment cases at the Ninth Circuit. So when you go to a circuit court, yeah, I mean, there's a lot of cases. So here's the deal. When you go to a circuit court, almost always it's heard first by a 3-judge panel. If whoever loses can petition the court for en banc rehearing, which means that you're asking the court to sit as a whole and rehear the case, which means they can do one of two things. They can affirm the 3-judge panel's decision, basically say like, yep, it's good to go, or they can overrule it and overturn it. And then from there, you could, ask the Supreme Court for review. So in every instance where somebody brought a Second Amendment case and won in the Ninth Circuit in that time period, those cases were reheard en banc, and the court as a whole came back and said, no, these laws are all constitutional. Every single one. So there were some wins, and then they got overturned by the en banc court. And that's what, yeah. And that's
so the Ninth Circuit is just like full of like anti-gun, like the most like.
It's not where you want to bring cases if you're looking from a strategic perspective, in as much as this is a favorable place to do it.
Or is it just like legal philosophy? Like what are we dealing with?
You're dealing with people that, judges are human, right? They're supposed to be impartial arbiters, but they have their own biases. And ultimately, if they can rationalize and put it in writing in a way that, they can make a compelling argument that they're right, they're going to rule how they what they think is right. And if they think that the government's right, or whether it's because they believe guns are bad, or they thought the government had a better argument, or whatever the case is, they can lay it out in words. So the Ninth Circuit's not where you would go to be like, yes, we want to go overturn laws and we know we're going to get favorable rulings, so-called forum shopping, if you will, like the Fifth Circuit, which has been pretty decent for Second Amendment stuff. Not perfect, but pretty decent. And so the problem is though, a lot of times these bad laws that you challenge at the state level, they're in states that are in bad circuits. So you can't even you can't even forum shop in the sense of like, well, we want to challenge an assault weapons ban in the Fifth Circuit, because there's no way that they would let that stand. The Fifth Circuit being comprised of Texas, Louisiana, and Mississippi, I believe. Um,
Mm.
and so you can't, because none of those states have assault weapons ban challenges. So you can't go there to challenge something like that.
Mm.
And ultimately, you're kind of stuck with what, it's kind of where the law arises in some contexts. And you look at where all of our assault weapons ban challenges are. I think the best one we have is kind of in the Third Circuit, which is Pennsylvania, Jersey, Delaware, and the Virgin Islands. So you kind of get stuck with where the thing exists, unfortunately.
Yeah, as someone who grew up in the Virgin Islands, we've had like the worst gun laws
Yeah,
ever. Some girl went to jail for having the wrong kind of ammunition because she didn't have a gun that fit that caliber. And
that's
what?
crazy.
And like, as a guy who has just random stuff, I'm just like,
Uh-huh.
I don't know what you're talking about.
Yeah.
How is that possible? Um, but I really appreciate you breaking that down. And just because I want to respect your time, I know we've really like went through a whole lot of kind of layering on how this actually works and where
Mhm.
people should kind of understand where the trouble is for groups like yours, trying to be strategic and not just take on every case. Let's talk about Washington State.
Yeah.
A member of my Discord, the Gun Club community Discord, if you've made it this far into the interview, God bless you. Thank you for being here. You're a real American, a true patriot, or a very interested person from somewhere around the world. And I appreciate you guys for being here and listening to Adam share. Um, join the Discord and say SAF, Second Amendment Foundation, so I know where you came from. The guy from our Discord, he was in Washington and felt he had to move for better quality of life and better Second Amendment rights, because getting any sort of anything was becoming incredibly difficult. He was able to get this and that. And we had a really rich and thriving firearms culture, gun culture. Some of the greatest gun bros in modern time have come from that area, the Pacific
Mhm.
Northwest. I think Grantham was in that area for a long time.
Yeah.
And he's well regarded, or he's prestigious in many ways. But then this law, an assault weapons ban, and he went down the list of all the different things, magazine bans. I don't want to just go down the list because it was like 20 items that he replied with.
Sure.
And he said, like, hey, why doesn't SAF litigate more? And I'm like, I don't know that they haven't, but I'll ask. Like,
Yeah.
what's up with that? That's the home base, Bellevue, Washington.
Mhm.
Go Hawks, right? But like, is Second Amendment Foundation active in Washington, or are you guys kind of worried like big picture? What's the deal with that?
Well, it's all big picture to a degree. Like regardless of where the case is, it's looking at a bigger picture. Now, having said that, we do have cases in Washington. We did challenge the assault weapons ban. We did challenge the magazine capacity restrictions. We had lawsuits against Seattle and I believe the city of Edmonds dealing with safe storage laws that they had. And there's other things that the organization before my time, I believe, has done in Washington as well. But those are the more contemporary examples that I'm familiar with. The most recent thing Washington did was pass a purchase permit, which goes into effect in 2017 and has a whole bunch of requirements for it. So that's something we're
I think
evaluating.
Chicago also has a purchase permit. Am I wrong?
The
Or is
Foyd,
it
well,
the
Illinois
Floyd?
does the Floyd card, and so does Jersey. They have a purchase permit as well. Um, so I mentioned the Ninth Circuit earlier. The Ninth Circuit's comprised of a lot of states, including Montana,
Montana.
Washington, Oregon, California, Arizona, Nevada,
Wow.
Hawaii, Alaska. There's
All the
probably one
most
or two that
anti-gun
I
states,
can't
minus like
remember.
Montana and Alaska.
Right. It's a big circuit. So to
You got to
try
look
to
that
answer
up.
this question a little bit, um, I mentioned California earlier. There are there's at least two, maybe three assault weapons ban challenges in California that are at the Ninth Circuit right now. There are magazine capacity restriction challenges coming out of California that are at the Ninth Circuit. There is a purchase permit case out of Oregon that is at the Ninth Circuit. And you kind of get the idea here. So while we have challenged some of these laws directly, and they're behind other cases as far as temporally, which means that simply if the court decides one of these cases, in our favor, it certainly has a positive effect. If it's a negative decision and it goes to the Supreme Court and the Supreme Court declines to hear it, well, then the next case in line is another bite at that proverbial apple, if you will.
Now, you
Point
said like temporally, does that create like a precedent, like case law type thing, or like what are we talking about?
So we're talking about like time when it was filed and where it is in the pipeline. So for example, if and let's just use two hypothetical states here. So if state A passes an assault weapons ban in let's say 2022, and we filed a lawsuit and that's on its way, it's now in the circuit court, and state B passed an assault weapons ban this year, and we filed a lawsuit against that in the same, let's call it in the same circuit for that matter. And the first case, the circuit says the law is constitutional. We seek cert, and the Supreme Court declines review. Well, you have your second case now that's on its pathway going up into the circuit court. Circuit court's going to say, we already decided the issue, so as a matter of law, you lose. And then you're going to the Supreme Court to hopefully have them overrule it. So essentially, you're just kind of teeing up a couple of different vehicles to get from A to B, and hopefully one of those does it. So when you're dealing with
That's a
different states,
strategy.
well, it's a general litigation strategy for strategic litigation across the board for, I think, many groups, not just SAF.
Yeah.
So the point being that while there are some cases that are duplicative, like the assault weapons ban and magazine capacity challenges, where we have those challenges in other states and Washington, there's some other issues like the purchase permit. Since that doesn't take effect till 2027, we're not rushing to go file a lawsuit yet, because right now we do have one of those there. And I think there's a couple other purchase permit challenges, not necessarily ours, that do exist throughout the country as well. And in particular, also Oregon in the Ninth Circuit. So some of it's also just a conservation of resources thing. If that issue is going to be decided, particularly by a circuit court, that circuit court's ruling, if the state's in it, like Washington in the Ninth Circuit, if you get a favorable decision, it would affect Washington's law without having to actually sue them right away.
Okay. So to make sure that we don't go broke hiring out externally all the lawyers.
Yeah, litigation's not cheap, and if we could do everything, and there's the manpower and money, we would do everything. But we got to be strategic in things, and we also only know what the board looks like today as far as what states have done. There's plenty of blue states that continue to dream up new ideas of how to screw gun owners that we need to pay attention to and be ready to
some
sue.
heinous dreams, some chainsaw fingernail nightmares.
Yeah.
It's just like, you guys are getting real creative with ways to tell me that, 10 rounds seems like a lot. Whatever happened to the days of 6 rounds in a revolver? That's all you need. If you need more than 6 rounds, you're not a man.
Well, like, guess I'm not a man then. I like my 30-round magazines. Thank you very much.
Very much. Very much. Give me a drum.
I think, yeah, and I think with the assault weapons ban in particular, I'll use Colorado as the example. They passed a law this year. Their law originally started out as a flat ban, so you just couldn't have them, and it evolved into a purchase permit scheme. And I'm going to guess that if the Supreme Court takes an assault weapons ban challenge and finds that a ban is unconstitutional, you're going to see all those states implement purchase permits and training requirements for them. Mark my words on that. That'll be their next play.
They want what they want, and they're going to get it one way or another. And so you guys
until they get smacked. It's a game of whack-a-mole, unfortunately. Like there's not going to be total victory because, well, maybe one day, but for the foreseeable future, unfortunately, it's just going to be a whack-a-mole because you get a positive decision. They come up with a new creative way to try to do the same thing or make it difficult to exercise your right, and then you have to deal with that on the back end through litigation. And if you're successful, then they're going to come up with some new way.
I'm guessing the best way to avoid having to do any of that is to basically stop only voting when it's like time to vote for presidents or whatever, and actually take care of your local bodies. And,
yes.
Actually, I knew a lady who Redstone Firearms. They had the crazy. Are you familiar with Redstone out of California?
I'm
Um,
not. No.
yeah, they were formerly they're one of the only black-owned gun stores, like with brick and mortar locations in the entire state, and they ran into an issue. This is how it was explained to me, um, where like the local body, was it the county or some commission or board or whatever, created a rule where if you were a firearms anything like an FFL and you had a brick and mortar location, you had to have like written permission from your landlord to be in his building, their building, and
The
you had to
building
have
that
it.
you have a lease,
Yeah. So don't
that
we
you have
love
a
written
signed
permission?
agreement that you can be in, like
Right. So you needed a second signed agreement that says we know
permission slip.
explicitly what it's for. It's almost like, did this guy just want to get you out? And so, you know,
Yeah.
he
I,
was in cahoots with the local government body and pretty
I
much
think
forced you out, or
I think generally as a matter of like practical landlord tenant, if you were renting a facility for somebody's business, you're probably going to ask what they're doing. I mean,
yeah, I
that
don't know.
like if nothing else, just out of sheer curiosity, like what are you going to use the space for?
Yeah.
Don't know.
Yeah. I mean, you're allowed to ask. It's not like,
Sure.
oh, you're not allowed to ask your potential employee that you're interviewing about their, like, orientation, like, or like what they like to do for fun on the weekends.
Yeah.
Like you can't
When's your
ask certain
birthday?
things. When's your birthday? How old are you, by the way? Yeah.
Right.
Like,
Sneaky way of asking the question. When's your birthday? What's the year?
oh yeah. So what were you doing where were you during 9/11? Oh, I laugh. Dark times. Too soon? I don't know. This has been really interesting because we're obviously, thank you for sharing um, kind of the breakdown of what's going on in Washington and really the Ninth Circuit, because it sounds like the Ninth Circuit is just giving you guys like a run for your money, and it's
It has a
not for a lack of trying.
it
Yeah,
has a nickname, the Ninth Circus. So, there
yeah,
are some good judges there.
I'm sure. How do you even get judges elected to the Ninth Circuit, or how does that work?
So all the federal court positions, as far as judges are, they're appointed by the president. So the presidency is important, particularly voting in the sense of, all the district courts or all the trial courts, they're all appointed by the president, confirmed by the Senate. Same with the circuit courts and especially the Supreme Court. So if you remember during Trump's first term, there were 3 Supreme Court justices that he put on the bench.
That was a lot.
Yeah,
Just
that
like,
was a
damn,
lot. That
how
could
many people are
materially
dying or
shape the court
retiring
for decades to come. And then
potentially?
right now, you have Thomas getting up there in age, and I think Alito is getting up there in age as well. And if they retire, he would get 2 more and kind of solidify the so-called conservative majority for decades to come.
Unless
So
they pack the
that's how they
court.
get appointed. Well, unless they expand the court, that could be. They need the votes to do that. But yes, if they
Yeah.
said they were going to do it, much like they said they were going to end the filibuster, and I
Oh, they
believe
won't.
that if they had, well, I believe if they had won, they probably would have tried.
And I think there's a reason why the Republicans didn't change out the parliamentarian. It sounds like a this human's well liked outside of other things, or
Mhm.
b, you don't want to set a precedent that for a sign of a little bit of trouble, we're just swapping people out. I don't know anything from anything. I'm just speculating.
I I don't have inside baseball as to what goes on in Washington. I can tell you that the parliamentarian has been fired before, but it's not a common occurrence. Um, so best I got on that one, unfortunately.
Okay. Well, I guess what can we expect from Second Amendment Foundation? I guess in this next phase, I know you kind of hinted at, oh, we're doing this and we're going to be doing that, but I guess at end of the year 2025, going into 2026, what's exciting? What should we be like? Hey, man, I got an extra $100. We got to support this right now.
Yeah, so I mean, there's two big things. One, obviously, the legal work's going to continue. We continue to have new cases. We're working on a bunch right now to work on getting filed. Typically, we don't talk about what they are before they are filed, but there's a number in the pipeline. In addition to, we have a number of cases that are currently just being litigated that we need to see to the bitter end on that. But I'm particularly excited about our educational program. That's something we didn't really talk about, and it's still a little hush hush, but I'm hoping by the end of the year we'll see that launched. And education's always been something that's been important to me, especially being able to impart knowledge to others. And I think it makes the gun owner more informed and able to have intelligent discourse and be able to make smart decisions and persuade others as to like either why gun rights are important, but also having an understanding of how government works and the just being a active participant in the political community. A lot of people I think kind of just shrug their shoulders and too much. I'm trying to kind of be very broad brushstroked on it, but I think come the end of the year, if we get it launched on the timeline I have set forth, it'll be well received because nobody else is doing it, and it's going to start with the Second Amendment in particular, and then kind of expand from there.
Well, that sounds pretty exciting, and I hope that top secret education initiative plays out the way that you're hoping it will. I think really, if you can help people gain like a foundational knowledge, they can make better choices. I mean, you said the same thing, just in different words, I think, or maybe the same exact words. But
I think your words were better, more succinct.
I'd say you're very kind, but then we've had this conversation before. I tell you what, guys. So, Adam, I know you do Second Amendment news with our guy, John Patton.
John,
are you going to be doing that for much longer, or is this like a trial run thing, or?
So I used to, and this is why the education is important to me. I used to do a show called The Legal Brief on his channel that ran for I think it was over 100 episodes, if I remember correctly, looking at the scripts the other day. And the whole idea behind it was that there were a lot of people putting bad information into the YouTube sphere as far as laws, gun rights, things like that, particularly the legal side and kind of what was going on in Congress at the time. So the whole idea behind that show was to better inform people as to here's the law, here's what it means, here's how it affects you in like a fun, easy to digest manner that was understandable, being the important part of that. And then once we ran out of federal laws to talk about, it kind of expanded from there. So I stopped doing that. It became a lot to balance with my day job. He had been asking me to come back and do something with him. And ultimately what we came up with was the Big 2A, which was kind of a roundup show of what was going on in the Second Amendment world. It's a bi-weekly show. We're currently kind of evaluating its performance, and we may be tweaking some things, or we may be revamping the format entirely to something else. I don't know, but it's kind of up in the air right now.
Yeah, I'm not entirely sure how he convinced you to do just a pure like caffeine syringe into your veins, because I know for the Instagram side, doing the 60-second, news, I'm just like, that's not you. That's not you. I don't know what you've done with that.
It's him going, get excited, get pumped. Are you pumped? And me going like, yeah, I'm thrilled. And then he hits record and I go, 60-second Amendment news, and right into it. Yeah, like
he looks you in the eyes, shakes you a little bit. Get excited.
Mm-hmm. Yeah. That's definitely not my. This is more my speed.
No, and that's perfectly fine. But the idea that you would do what must be done to capture people's attention just for like 30 to 60 seconds, just to kind of help people have a better idea of what the heck is going on, actually. Because I mentioned this kind of earlier, I think I did. I had a buddy who we were talking about some stuff just this past Saturday, and he was like, yeah, I'm thinking about getting this and that. And yeah, that didn't work out with the thing. And just talking about like the recent, cases up, not the case, but the recent laws going through Congress and the Senate. And what I know and what he said were two different things, but I was like already in such a hurry that I didn't really have time to just challenge him. I was like, okay, all
Yeah.
right, we'll talk about this later. And I wish people had like a really good source of, oh, wait, they do. Oh, wait, they do. A good roundup. And obviously, if it could be longer, if it could be more details, that would be great. But you do and are important to the work that SAF is doing. And we appreciate you lending yourself over to the entertainment side so that maybe we could get just a little bit more knowledge.
Yeah. No, it's fun. Like I said, I think ultimately my favorite part about it is when somebody learns something. Now this show I think is a little more of a roundup where I do try to impart some knowledge, but it's not like what I used to do where it was really like you walked away learning something, a lot of
Well,
something, probably more than you
hey,
ever
well,
wanted to know.
it sounds like you have a plan for that, and some way, somehow, you'll figure it out.
Yeah.
If I know anything about you, and I just met you, it sounds like you're the type of guy to get something done if you really put your mind to it. So let's get
So
it
I've been
done.
told.
So he's been told. All right, let me do the outro, and we'll get out of here, guys. Thank you so much for watching, listening, wherever you are. My name is Aaron. This is Gun Club Radio, and I'm really happy that you found a way to make it to the end of this. If you made it to the end of this, type SAF win. That's SAF space WIN in the comment section. And if you're on the actual like RSS feed, um, shoot me over an email, info@costlymedia.com. Would love to hear from you. See what you have to say. If you enjoyed this show, if you want more deep dives, I know this is kind of technical and not everybody's going to be into it, but for those who are willing to stick to the end, I hope you enjoyed it. All right, guys. See you next time. Peace.